Good morning and welcome, everybody. My name is Dana Sparks, and I am the director of the Real Estate Academy of America, which is the school offering this course for CE credit. I am also the qualifying broker of Maximum One Greater Atlanta Realtors. I tell you that because this is a contracts course, and I see a lot of contracts. I do not see every contract. We have a separate compliance broker that reviews each and every contract. I just see the ones that have issues or questions or something interesting going on. So, just a couple here and there. But I just wanted to give you that contextual background so that you will know my current ongoing interaction with the contracts. Today's class, I really enjoyed teaching this class. I enjoy teaching all classes. That teaching is probably the my most favorite thing that I do of my jobs. I'm what's called a non-competing broker, meaning I don't actively interact with the public in a sales or listing capacity anymore. Obviously, I interact with them on contracts and questions, but I manage the company. I interact with co-op agents, co-op brokers, and the public on those kinds of things. I direct the school and I teach. So of all of the many hats that I wear, I really, really enjoy teaching. The Real Estate Academy of America, as well as Maximum One companies, we place a huge value on training and education, which is why we offer a ton of CE classes every month, and we do our best to make these either free or extremely low cost, and we welcome agents from all brokerages. We believe that it is in the best interest of the industry as well as of agents and the public. The more training, the ongoing training, the more current, the more education that our agents can get, the better it is for them and their brokers as well as for the public. So we make our education, our real estate education, as accessible as possible. To that end, we also record a lot of these these CE classes. You can watch the recording. You can't get CE credit just for watching it. But they are, these trainings are available as well as our handouts. Again, we believe that it is in the best interest of our industry and our public to make training and knowledge available to everyone. So that training is available at, I have a YouTube channel called Real Estate Made Crystal Clear, and there is a playlist of CE classes that you can get those there. Or you can go to www.eagentweb.com, select the tab for training videos, and scroll down that page for recorded videos and handouts. But on to today's class. Today's class is the 2023 Contracts Review, the GAR, or Georgia Association of Realtors contract forms, versus the RE contract forms. And it is GREC course number 75554. Before I get into that, let me give everybody just a brief history, very brief, of these contract packages and how they came about and all of that stuff. Well, the Georgia Association of Realtors has copyrighted, licensed a contract package for many years that all real estate agents utilized. And then in 2008, when the economy and the real estate market got really topsy-turvy, there were a lot of brokers. Well, even let me back up a little bit more. Well, let me just, I'm not going to cover all of that, but basically in 2000, anyway, GAR started charging agents. If you were not a realtor, if you did not belong to a local board of realtors, then the Georgia Association of Realtors was not getting dues money. Neither was the National Association of Realtors. So GAR said, you know what, we absolutely don't mind sharing our contracts, but if you're not already paying for them by being a member of GAR, you can use them, but you have to pay for the licensing fee for them. So a lot of brokerages that did not belong to boards and FMLS and Georgia MLS collectively saw the need for another set of contracts to offer agents in Georgia at no cost. And that was what prompted the birth of the RE forms initially in 2012. And they have undergone a lot of changes. There was a radical change in 2014, 2015, additional changes in 2019. And a lot of agents, at least in Metro Atlanta, refer to these forms as the FMLS forms. I'm not sure why. I imagine it's because they are available to agents typically through an MLS system. And in Metro Atlanta, through FMLS, most people just call them the FMLS forms, but they are the RE forms. They are available to agents in Georgia at no additional cost. And agents also have the option to use the Georgia Association of Realtors license forms. You either have them at no additional cost to you if you are a realtor, or you can pay GAR every year for the licensing to use their forms. So there are a myriad of contract forms out there for real estate agents to use. However, to initiate a contract, to initiate an offer, typically agents have access to either the GAR forms or the RE forms. Those are the two most readily available forms to initiate a contract. Like I said, there are a number of contract forms that real estate agents in Georgia utilize. There are the GAR forms. There are the RE forms. There are HUD contracts. There are Fannie Mae, Freddie Mac contracts. There are builders contracts. A lot of builders contracts come from the Atlanta Builders Association, and they are not GAR authored or licensed contracts. They are from the Atlanta Builders Association. There are a lot of attorney written contracts. There are a lot of investor contracts. Again, there are a number of contracts that real estate agents and brokers use and allow their agents to use. And since we are not attorneys, we are real estate agents, it is our job to explain the contracts to our clients, but it is our clients, our buyers and sellers' choice as to what contract they use. Again, these two contracts are the most readily available contracts for an agent to initiate an offer on, and that's why I cover this class, because these are the two. Because of that reason, I feel that it is important for agents to understand the similarities and the differences in the contracts. So that is the rationale for this class. A lot of similarities, a lot of differences. I really, really appreciate agents taking this class. There's not a lot of training on the RE forms. Through the Real Estate Academy of America, we teach this class, which is a direct head-to-head comparison and contrast of the two forms. We also teach a full 3-hour CE class just on the RE forms in and of themselves, and on the GAR forms in and of themselves, as well as the brokerage agreements and so forth and so on. But this is a great class just to get an overview of those differences. So sit back, relax. I really enjoy teaching, and my goal is at the end of the 3 hours, you will have, number one, said, wow, that time went by very quickly. And number two, really enjoyed the class, and the 3-hour CE credit will be the bonus to you and not the reason for being here. So we are going to get started. I am going to share my screen. This class is you'll see as I get into it, it is a bit tricky to teach virtually. When I teach this class in person, everybody has the handouts of all the classes, and it's a little bit easier to sort of spread out and see everything. So I'm going to do that via the computer, via sharing my screen. It's going to be a little frenetic at first, but you'll get the hang of it as I go through, and all of that will make sense in just a moment. Additionally, I will answer questions via the chat, and I will stay on at break and answer the question, or after we get back from break, answer questions and stay on afterwards. So let me share my screen and we shall get started. All right. Oops. Make that small. I do have the chat open in front of me, and now I have to put on my glasses. All right, and let me make this a little bit bigger so everybody can see it. I do have a computer. You will see me looking to my left, and I do have that so that I can see what you guys are seeing. There we go. All right. Today's class, as I mentioned, is the 2023 Contracts Review, GAR versus the RE forms. It is Georgia Real Estate Commission course number 75554, offered through the Real Estate Academy of America, which is GREC school number 6915. There are 3 handouts. The first one is the table of differences. The second one are the actual GAR forms, and you'll see this is handout 2. And again, these are available for you guys to download. I'll go through that again in just a moment, or at the break. And then the third handout are the actual RE contract forms. So we are going to bounce among the 3. So what is this? I don't want that. All right. Again, I am the instructor, Dana Sparks. There is my email address, and our website is keepmorecommission.com. For the notice to students, again, the school, I need to change that. It is the Real Estate Academy of America. We were formerly the Georgia Real Estate Academy, and our school is renews in 2026. This is a classroom, actually this is obviously a virtual class of an approved in-class course for 3 hours of CE credit, no prerequisites and no homework. In general, for any virtual class, you may only take 1 virtual CE class at a time, or with overlapping times, regardless of the school offering the course, in order to get CE credit for either course. If it was an in-person class, you can only attend 1 class at a time. So the same is true virtually. In order for us to mark attendance, we do that via the chat function, as well as via the registration and attendance information that the Zoom software package records. So I will ask you 3 times. If you've already done so, you don't need to do it again, but I will ask you 3 times during the course of the class to type in your name, your real estate number, your email address, and your license number in the chat. When you first come on, when you get back from break, and before you leave. Additionally, I will ask questions throughout the course. In the interest of time, I don't have time to wait for everybody to log in their answer in the chat function. But if I do ask a question, I will prompt you to put it in the chat. Go ahead and type your answer in the chat, even if I've already given the answer. That way, we can demonstrate that you are actually in attendance in the course and paying attention and answering the questions. GREC will only give CE credit to a student once every 12 months for a specific course number. Now, that's not on a course topic. That is just a course number. So you can take a number of classes on contracts, GAR and RE forms, but you only get credit every 12 months for this specific course number. So if any of you have attended our classes through our school before, we've taught a different course last year called the 2022 Contracts Review, GAR versus RE form, and it did have a different course number. So We send those in to get to keep current with the contracts, as well as to get a different course number. There is no recruiting. If so, please report promptly to myself, to Heidi Kelly, who is the coordinator of the Real Estate Academy of America, and that is her email address, or to GREC directly. And now on for the class. So let me structurally show you how we're going to do this. And then this will make sense. So this first handout, I've got a table of the similarities and the differences. So in the column, you'll see the issue. You'll see how it is addressed in the GAR contract package, where it is addressed in the GAR contract package, how it is addressed in the RE forms contract package, and where. So in general, the date on the forms, GAR, and we'll go through this, but in the date on the forms, the Georgia Association of Realtors updates their contract package every year. So they do it towards the end of the year, so that every January 1st of every year, there is a new contract package, and the date on the bottom of the contract package is printed there. They put out a new package every January, and then around April or May of every year, they do a revision. That mid-year revision is typically to correct any syntax errors, grammatical errors, spelling errors, things like that. And every now and then they throw in some real doozies of that really impact and change the content of something that was in the form. Part of GAR's licensing agreement is once the new version of their contract is out, you are prohibited by GAR from using a previous version of their contract. So now that the 2023 contracts are out, it is a GAR licensing violation to use any forms from 2022. Now, if you were under contract in 2022 and your deal hasn't closed yet, or you had a seller that signed a listing agreement from 2022 and it's still active, that does not mean you need to go back and re-sign it. It just means that any form you initiate after the new package is out must be on a new form. And the sanction, GAR can sanction you or your broker if you use a previous version of their form. They can withdraw your license to use their forms or your broker's license. The RE forms, the dates on those contract packages, each form has a date based on the last time it was revised. They do not do an annual revision of their packages, and they don't have anything in their licensing agreement about using the current form, because they don't redo them every year. Going on to the fill in the blanks on the GAR contract package, just about every form at this point, the fill in the blanks are on the first page, the first 2 pages of the forms, and then the rest of the explanation for the agents, for the buyers, for the sellers is in the ongoing pages throughout that contract package. In the RE forms, the fill in the blanks are throughout the entire contract within the context of the paragraph that the issue is being addressed. The GAR form is the basic residential purchase and sale agreement is a total of 9 pages. The RE forms, they handle their contracts a bit differently. And the way they handle it is the contract in and of itself is 5 pages. And then they have an additional document called the standard terms that is 9 pages. Those standard terms contain the additional information, the obligations of the buyers and the sellers, the consequences to the buyers and the sellers for not meeting those obligations. And so the actual contract, and you'll see this when we actually get into the forms, is RE form number 100, and the standard terms is form number RE1. And then the actual forms themselves. The Georgia Association of Realtors, they have a huge library of specific forms for a variety of situations. The RE contract package has a lot of multi-use forms. Just as an example, GAR, for example, has an amendment to the sale price or a separate amendment to extend the closing date. The RE forms has a general amendment to the contract that you can use for a variety of situations, and you just indicate on that what is being amended. All right, so now let's get into some specifics. So the names of the parties. In the GAR contract package, you only write out the actual names of the parties on the signature page. In the RE forms contract package, you have the names of the parties on the front page and the signature page. So that's just a little bit different. It can be very helpful in an extremely fast market where a seller is getting multiple offers to have to consider and work through simultaneously. Sometimes it's nice to attach a name to the actual offer, but that is where the names appear. Signatures and initials. In the GAR contract package, there is a place for initials at the bottom of first page, and then the parties actually sign on the last page or the signature page. In the RE forms contract package, there is a fill in the blank for initials on every page, and the parties actually sign just the signature page. So let me show you what I'm talking about, and then we'll start to get into these other specific issues: closing costs, earnest money, so forth and so on. So this is the GAR package. All right, so this is the 2023 GAR purchase and sale agreement. And so let me show you first. Here's where the buyer initials and the seller initials, and it's only there is the only place for their initials. And then on these are the RE forms contract package. And in the contract in and of itself, let me make this a little bit bigger for you. Here's where you put in the names of the buyer, the names of the seller, and you will see these initial spaces at the bottom of every page of the contract, and then their signature page at the end. So before I even move on, again, the GAR, let me get rid of this. The GAR form, all the fill in the blanks are in paragraph A on the first page. Some of their forms, it rolls over into a second page. And then the rest of the contract is further explanations to corresponding paragraphs. And there really are not fill in the blanks here. This is just the explanations to the buyers and sellers, what they are agreeing to, what their responsibilities are, and the consequences for not meeting those responsibilities. All of that is contained in these 9 pages. While I'm here too, let me show you also, here is the date, the latest date of the GAR form. So you'll know if you're using the January version. If there is a document that gets revised mid-year in May, it'll have that date down there as well. In the RE forms, the fill in the blanks are throughout based on in the paragraph of what you are talking about: closing date, contingencies, so forth and so on. You'll see, for example, the actual contract, it was last revised in 2019, and this is 5 pages. Remember, I talked about the standard terms. Well, the way the RE forms package handles the standard terms, again, that's all the legalese or the promises and consequences that the buyers and sellers make to one another. On the contract in and of itself, in bold caps, it says this contract incorporates by reference those standard terms for the purchase and sale of Georgia Real Property, published by Orthros Real Estate Enterprises at. So this website here, that is where the public can go to get a copy of the standard terms. You, as a real estate agent, you have access to these standard terms wherever you get your contracts, whether that be through FMLS or Georgia MLS or whatever MLS system, wherever you get your contracts, you have access to this form as well. The standard terms do not have any place for agents to sign for the public, your buyers and sellers, to sign or initial, because they are incorporated by reference. And it says, in effect, as of the offer date, the standard terms are part of the contract. And when your buyers and sellers sign this offer, they agree that they have gone to this website, read the standard terms, and it is their intent that those standard terms are incorporated and part of this contract. Point of practice to you agents. I highly suggest that you demonstrate, because you have readily available access and you know how important all that information is. I highly suggest that when you are pulling out this contract to fill in the blanks on behalf of typically a buyer to submit an offer to a seller, that you also pull out and attach these standard terms and reference them as an exhibit. So the question is, do they have to be included? No, by reference, they are included. But I'm telling you, you guys make sure your clients and your customers understand what it is that they are signing. And hopefully none of you, but should you ever be in front of an arbitrator or a GREC investigation or a judge, you want to be able to demonstrate that you know how important that document is. And you made it easier for your clients to have access to it, to what it is they are agreeing to. That's why I highly suggest, as a point of practice, you attach them so they physically have them attached and referenced as an exhibit when you are filling these out. Now, your public people, when they sign this offer, they're saying that they have gone online to this website and read these. Have they done that? I don't know, but don't leave it up to chance. All right, so now let's go on to, let's talk about the difference, how the different contract packages handle sale price and closing costs. So again, how to read this chart. The issue we're going to talk about is sale price. The GAR contract package handles it in numerals only. And where you can find what I'm talking about is in Form F201, paragraph A2. The RE forms handle sale price in numerals and words. You can find that in Form RE100, paragraph 2. So that's how to read this chart, and then let me demonstrate where that is. So here we go. This is the GAR. Sale price, paragraph 2, Form F201 is the resale purchase and sale agreement. F201, you write it out in numbers only. When there is a fill in the blank preceded by a $sign, it calls for numbers. Same thing with closing costs, calls for numbers. In the RE forms contract, I didn't address legal description because that is handled the same in both. You have to attach a legal description, and the references to legal description are the same. But here, where we're talking about purchase price, in the RE forms package, you write it out in words. It's a fill in the blank with no $sign beforehand. So you write it out in words, and then to make sure there's no mistakes, you write it out in numbers. And you'll see when we get to closing costs. Oops, did I pass it? Closing costs. Well, I'll handle it. I'll come to that in a second. Pop quiz for everybody. If you write out a dollar amount in words and in numerals, if there is a discrepancy, if there is a difference, which takes precedence, the words or the numbers? Type it in the chat. Yes, you guys are correct. If there is a discrepancy between a written numeral, a written number, and a number spelled out in words, the words take precedence. All right, the closing cost amount. In the GAR contract package, it is addressed as a specific dollar amount. In the RE forms contract package, it is expressed as a dollar amount or a percentage of the sale price. So let's look at that. Here's the GAR contract. Closing costs. Seller's contribution at closing is X amount of dollars. And in the RE forms contract, it's in paragraph 5, seller shall contribute a maximum of, you have one of two checkboxes, either a certain percentage of the purchase price or a specific dollar amount. That can be kind of a benefit if there are counter offers back and forth between the buyer and the seller. Also, it takes you as the agent out of having to predict what the final sale price will be. Typically, a lender, the closing costs for a buyer's loan typically are a percentage of the purchase price. And if you express the seller's contribution to a buyer's closing cost as a percentage, if you make an offer on behalf of a buyer and a seller makes a counter offer to the price, you don't necessarily have to also recounter the closing cost contribution if it is expressed as a percentage, because that actual dollar amount will change accordingly if it is a percentage of the sale price. Another thing that you will start to see, if you are an agent who has been practicing real estate in Georgia for over 25 years, you might remember that closing costs in the GAR contracts used to be expressed as a percentage of the purchase price. They have since changed it to a dollar amount, but that is a big difference in the two contract packages. Now let's talk about earnest money. So they both address how much the earnest money is going to be, who holds the earnest money, what is the form of the earnest money. But the GAR contract package goes on to address what happens if the closing attorney is the holder of the earnest money. So the earnest money in and of itself is addressed in the GAR purchase and sale agreement, paragraph A6. In the RE forms, you'll see it is a combination of our RE 100, and it doesn't address the closing attorney. So let's take a look at that. In, did I miss closing date? No, closing date is handled the same on both. It is an actual closing date, and possession is either closing or so many days from closing. That's the same in the RE contract package. Closing is a specific date. The RE forms does go on to say the closing attorney, and it itemizes a specific office, just because we have some closing attorneys that have offices throughout town. And then possession is the same thing, either immediately at closing or so many days after closing. So those are addressed the same way. But let's go back up here to earnest money. So this is the amount of the earnest money. And again, in the RE forms package, the dollar is spelled out in words and in numerals. Here is the holder. You write out who it is payable to. Here is the form: check, certified funds, money order, or cash. It doesn't say anything. There's nothing in here about a closing attorney as the holder of the earnest money. In the GAR form, same thing. Here is the holder of the earnest money, here's the amount, check, ACH, cash, or wire transfer, either immediately as of the offer date or so many days from binding agreement date. It is handled the same way here. Either it is, this is the section where the buyer has it on with the holder at time of the, that you're writing the offer, or the buyer has not remitted it and shall remit it so many days after the acceptance date. One thing to keep in mind too, the RE forms contract package, they use the term acceptance date to mean the same thing as binding agreement date. So that is the same. Either you have it in hand at the time you are writing the offer, or the buyer will send it to the holder so many days after binding agreement date. That is handled the same way. What's different is regarding if the closing attorney is holding it. So this, the GAR says, if the holder is a closing attorney, then the parties, you must have form F510 attached as an exhibit, and then F511 must be signed by the closing attorney at a point later in time. The RE forms does not address anything if the closing attorney is the holder. This is important. Dana, why are you spending so much time on this? Because who signs the contract? The buyer and the seller sign the contract, and you as agents sign the contract on behalf of your broker. A closing attorney does not sign this contract. There are very specific items, duties, and responsibilities of the holder of the earnest money. Those are all itemized in the contract. This is what the holder of the earnest money has to do. They have to make the deposit. They have to accept the form. A lot of holders won't accept an ACH deposit. They have to make the deposit. If they never get it from the buyer, or if they get it from the buyer, but the bank doesn't honor that, like the check bounces from the bank, the holder is responsible for giving notice to the buyer and the seller that the buyer is in default. The buyer then has a time frame to cure, and then if they don't cure, the seller can terminate. So those are very important rights. Those are very important responsibilities of the holder of the earnest money, because they impact the buyer and the seller. Is the seller going to stay off the market for 30 days? How is the seller going to know that the holder never got the earnest money? The buyer defaulted and never put up the good faith money. Additionally, what happens once the holder has the earnest money if it doesn't close? How does the holder get the earnest money back to one of the parties? All of that is spelled out in the contract. So number one, the buyer and the seller rely on this in the contract as to what happens to that trust money. Number two, when you as an agent sign a contract and your broker is named the holder of the earnest money, your broker has given you the authority to sign the contract in their name and say, yes, I agree to fulfill all of these responsibilities with somebody else's money when you sign the contract, and I'm itemized, I'm named as the holder of the earnest money. Now, nowhere in the contract does your closing attorney sign agreeing to fulfill any of these responsibilities. And nothing's an issue until it's an issue. But when it's an issue and there's earnest money up for grabs, it becomes a big deal. And the buyer wants to know, what happened to my earnest money? The seller, don't you think, would want to know if the buyer never put it in and they've wasted their time? Or if a buyer defaults and the seller gets that earnest money back as liquidated damages. These are very, very important responsibilities that a holder has. So again, there is a closing attorney that is labeled as the closing attorney who's going to close the contract. Well, here's where you itemize the closing attorney. But when it comes to all the responsibilities as the holder of the trust funds, again, that is not addressed in the RE forms at all. It used to not be addressed by the Georgia Association of Realtors forms until a few years ago because of this issue. So now, how does GAR address this? Well, let's talk a little bit about how GAR handles this. And I have this a little bit further on in the notes. Let me find it and I'll show you. Somewhere. All right, where is it? Maybe it's here. Here we go. Now this, in the GAR contract package, this is form F510. And you'll notice this is an exhibit, meaning this is attached to your buyer's offer or to your seller's counteroffer. This is part of the contract when a buyer and seller go binding. And this identifies the closing attorney. This also says that it is the buyer's responsibility to get the earnest money to the closing attorney within 2 days from the binding agreement date. And then the closing attorney has 3 business days to agree to be the holder or not. There are a lot of closing attorneys that won't agree to be the holder of the earnest money, number one. Number two, there are a lot of closing attorneys that will not agree to hold the earnest money until they actually have the earnest money. And then it says what the rights and the responsibilities of the closing attorney as holder are. Now, you must name an alternate holder in case the closing attorney does not agree to be the holder or they don't sign that agreement. And if for whatever reason you forget to fill in this blank, the alternate holder by default becomes the buyer's broker. Now, you agents, this is not a GAR contracts class. We go more in depth on this, but just so you know, since we are here, if it is an all cash transaction and the buyer and seller have named a closing attorney as the holder of the earnest money, the contract doesn't close, buyer and seller do not agree on the disbursement of the earnest money, the closing attorney is obligated to send it to court. There is a lawsuit over the earnest money and a judge will make that decision, and there are costs associated with that. That is the only remedy available to the closing attorney to resolve the dispute regarding the disbursement of earnest money if the buyer and seller don't agree. If a broker is holding the earnest money, even in an all-cash transaction, a broker may interpret the contract and find out why it didn't close, and the broker may send a notice of their intent to disperse the earnest money, that 10-day letter. All cash closing attorney can't do that. But anyway, back to this. This is an exhibit, so the buyer and seller initial this. Now, after you're under contract, the next form, this is form F511. This is what the closing attorney signs, and you'll notice it's not called an exhibit. This has nothing to do with the buyer and the seller. Buyer and seller don't sign this. The buyer and seller sign that exhibit identifying the closing attorney. Then after you're under contract, the buyer is responsible for getting the contract and the earnest money to the closing attorney and getting the closing attorney to agree to fulfill all those responsibilities as holder. Deposit the money, send notice if they don't have it, disperse the funds, so forth and so on. You identify the buyer and the seller, and the only signature on this agreement is the closing attorney. So only signed by the closing attorney after the buyer and seller have a binding contract, not part of the contract. Again, if the parties go binding on the RE forms, this is not addressed at all. So if you're binding on the RE forms and you have the closing attorney named as the holder of the earnest money, you better be careful what you're telling your buyer and seller regarding what happens to that, because that is spelled out what happens to the earnest money, what happens if it doesn't close, what happens if the buyer doesn't send it in or it bounces from the bank, termination rights of the seller, default on behalf of the buyer, all of that stuff is spelled out regarding earnest money. But guess what? A closing attorney doesn't sign. So the closing attorney doesn't agree to fulfill any of those responsibilities. So if you go binding on the RE forms and you say, oh, your earnest money is safe, and you tell a seller, oh, well, we'll get notice if they don't send it in. No, the closing attorney is not obligated to do that. And if you're binding on the RE forms, even on the GAR forms, if you're binding on the GAR forms and you itemize, you name a closing attorney as the holder of the earnest money, but that closing attorney never signs that form F511, they never put in writing an agreement to fulfill those responsibilities. If it terminates, the closing attorney, now they can't keep the money, they can't do anything illegal, but they can give it back to the buyer regardless. And we've had a lot of closing attorneys in the past that have given the earnest money a clear buyer contractual default, and the closing attorney has given it back to the buyer, and they said, I got the check from the buyer, I'm giving it back to the buyer. And you say, well, but the buyer defaulted. You agreed to fulfill the responsibilities as holder. And the closing attorney says, I never signed anything agreeing to any of that. I'm giving it back to who I got it from. It's not closing. There's no earnest money in this transaction. Buyer and seller, work it out yourselves. So you need to be very cautious when talking to your clients about the holder of the earnest money. Additionally, if a broker is holding the earnest money, a broker can't just give it back to their client willy-nilly, because your broker and your companies are also held to license law. I can jeopardize my broker's license and I can jeopardize my company's license by just giving money back to my client regardless of what the contract says. Like I said, a closing attorney can't do anything illegal with the contract, but unless they hold a real estate license, they're not held to license laws like brokers are. So that's a pretty big difference regarding if the closing attorney is the holder of the escrow. So I should have put it in here. Point of practice. If you go binding on the RE forms, what should you do? If for whatever reason the parties want a closing attorney to hold the earnest money. And why do your buyer and seller want a closing attorney to hold it? It makes sense if it's a cash deal. Well, not if it's a cash deal, because if there's an issue, but it makes sense if there's a quick closing. But I really don't understand why you would want a closing attorney. Closing attorneys are great at closing transactions. Brokers, day in and day out, interact with these contracts and understand these contracts and the nuances and what's going on with the contracts, and we're held to license law. So a lot of the public, I think, mistakenly thinks, ooh, it's an attorney. Well, closing attorneys specialize in closing transactions. Just like a doctor specializes in, you're not going to go to your general practitioner for a heart issue. They all have a degree. They all have an MD degree, but they specialize in different things. That's number one. Number two, I believe sometimes your public might mistakenly think that a closing attorney is a neutral third party, whereas a broker has one of the clients in the transaction. Yes, one of the brokers has a client in the transaction, but having a broker's license, your brokers are held to the standard of when it comes to making a decision regarding somebody else's money. We have to take off our client hat and put on our neutral, do the right thing hat and look at the contract, what the buyer and seller agreed to, and what did the contract say, and do the right thing with the funds to honor the contract and honor the public, as well as to protect our licenses. A closing attorney, if you think they're neutral, let me ask you this. Are closing attorneys trying to get your business? Do closing attorneys have relationships with certain agents and certain brokers? You guys represent their income, and they are neutral. Just like I'm not saying they're going to do the wrong thing, but they have relationships with agents and brokers, just like brokers have relationships with the public. So there's just a lot more going on there. All right. Again, regarding the form of the earnest money, that is handled very similarly. Due diligence period. Let's move on to that. So, due diligence period, or in the RE forms, this time frame is referred to as the buyer's general right to negotiate, to terminate. Sorry about that. In the GAR contract and in the RE forms contract, it's handled just a bit differently. Very similar, but additional option money is handled a little bit differently. So let's look at that. So when we come to due diligence, again, due diligence period is a certain number of days from the binding agreement date. And this paragraph says option payment for due diligence, because basically when a buyer and seller agree to a due diligence period, a seller is granting the buyer the option to terminate for any or no reason within this time frame, and they will get their earnest money back. Same thing in the RE forms. This is handled in paragraph 6. It is called the buyer's right to terminate. Same time frame. This contingency shall expire at 11:59 p.m. on the day that is so many days after the acceptance date. Remember, I told you that's the term they use for binding agreement date. In consideration of the seller granting the buyer the right to terminate, the buyer has paid the seller $10, non-refundable option money, receipt and sufficiency of which is acknowledged. Same verbiage here. That $10, you guys, that never changes hands. That's just legalese because you're creating a little mini option contract within the broader context of the purchase and sale. Now, so that's exactly the same. What is different is the GAR contract package has this extra paragraph that says the buyer shall pay directly to the seller additional option money. This is not in addition to the earnest money. The addition is in addition to this $10 that never changes hands. X amount of dollars, and it goes directly from buyer to seller and is completely non-refundable. The RE forms does not address anything about additional option money. I, as a broker, do not see this unless it is an extremely competitive market, which we were in about a year and a half ago. We're still in a competitive market, but it is not the hyper competition where sellers are getting 20 offers. We're getting a lot of sellers only getting one offer, sellers making concessions to buyers, sellers coming off of sale prices. We're seeing much more of a normalized market now than we did a year and a half, 2 years ago, where sellers were not giving any concessions to buyers, sellers were getting over sale price, so forth and so on. So in that hyper competitive market, a lot of buyers were trying to make their offer stand out to a seller in a highly competitive situation by being willing to give the seller additional option money that was completely non-refundable, again, as an enticement for a seller to choose their offer over a competitive offer. I'm not seeing that anywhere nowadays. All right, and then moving on to the labels for the brokers. Both GAR and RE now refer to the brokerage working with the buyer as the buyer's broker and the brokerage working with the seller as the seller's broker. That has always been the language. It has it further on in here. That has always been the language of the RE forms. GAR changed that 2 years ago. And so if you are a newer licensee, you might hear an experienced agent or an agent who's been in the business for a while refer to the brokerage working with the buyer as the selling broker and the brokerage working with the seller as the listing broker. Well, obviously, listing broker makes sense working with the seller, but it gets really confusing, not only to newer agents, but to the public as well. When you refer to the broker and the agent working with the buyer as the selling broker or selling agent, because they're not selling, they're buying. So it does get confusing. And a couple of years ago, GAR changed that terminology. All right, now let's move on to more of the legalese, or what your buyers and sellers are actually agreeing to, and what the consequences of them not fulfilling the responsibilities that they say they're going to do. Again, in the GAR package, it starts on paragraph B. And in the RE forms package, there is a little bit in the contract itself, but the majority of this is the standard terms. So here's a lot of the things we're going to talk about. The deed is the same. It is both the seller is conveying deed to the buyer by limited warranty deed. The title must be good and marketable title, which means that is a title that a buyer may get title insurance for at regular rates with standard exceptions. That's the same. And where we start a little bit of differences is with the closing costs. So let's look at the contracts and see what that says. So again, all these other things that I'm going over, we cover these in depth in our actual contract classes. If I'm not addressing it, it's pretty much the same in both. I'm just trying to point out a lot of the differences. So this is the GAR contract package, and where it talks about the seller's contribution to the buyer's closing costs, it does specifically state that it is what the lender may use on behalf of what is required costs or expenses of the buyer related to this transaction. You agents who haven't done anything quite yet, in 2023, GAR added that a seller's contribution to a buyer's closing costs may also be used for any commission obligations of the buyer. So that's new in 2023 if you haven't yet done a contract where a seller is contributing to a buyer's closing costs. And then in the GAR contract package, it goes on to state that if a seller has made a contribution to the buyer's closing costs, and after the lender uses them up, if there's any leftover money, it goes back to the seller. And it says any unused portion of the seller's monetary contribution shall remain the property of the seller. In the RE forms contract, again, closing costs in and of themselves are talked about in the contract, but what they may be used for, now we have to go to that separate document, which is the standard terms. So these are the standard terms, and let's see what it says. Here's where it talks about good and marketable title, limited warranty deed, so forth and so on. Here's where it talks about what happens if the buyer doesn't send in the earnest money, termination rights of the seller, if it's not cured, so forth and so on, what the holder is required to do. All of the things I've already addressed. But now let's look at what it talks about closing costs. So here, under the closing costs section, if the parties are binding under the RE forms, it states that the closing cost allowance agreed to by the seller in the contract may be used, again, the lender's going to use them for the costs associated with the loan, and the buyer may use them, may be used for any purpose whatsoever, mere or to offset the cost required by the lender, HOA, costs of financing, title insurance, so forth and so on, or merely at the discretion of the buyer. In other words, a seller, whatever dollar amount or percentage of sale price they've agreed to for the buyer, the closing attorney is allowed to use that full contribution to offset the buyer's costs at closing, even if it goes above and beyond lender loan related issues. Nowadays in the GAR forms with that commission obligation, a lot of times we're seeing a lender using a lot or the closing attorney using all the seller's contribution anyway, but that's just a difference in how it is spelled out. Now, when we come to prorations, where it talks about the property taxes being prorated, in the GAR form, it says the fees to be prorated based on estimates and any differences to be negotiated directly between the buyer and seller once the actual bills come out. And the prorations paragraph also talks about appeals and liabilities. And that's under this section. And basically any pending tax appeal, if it hasn't been settled, the buyer gets the benefit or the cost of that. And if there is a tax liability, if the property owes, if taxes on that property have not been completely paid to the county or the city, if a buyer closes, the buyer is then responsible for any outstanding liability of property taxes. In the RE forms, again, this is all addressed in the standard terms, and it is in paragraph 5.2. So let's look at that. That's up here where it talks about prorations, and it basically says that the closing attorney uses the latest information they have regarding the property taxes, and it could be an estimate. When the actual tax bill comes out, buyer and seller agree between themselves to settle up any differences. So that's the same. GAR goes on to specifically address appeals and liabilities. Again, liability for ad valorem property tax is addressed in the GAR contract, that the buyer is responsible. If there is an outstanding appeal or question with the county, it is not addressed by the RE forms contract package. All right. Now let's talk about a huge difference. This is probably one of the biggest differences between the packages, is a delay in closing. So again, in both contract packages, buyer and seller itemize a specific closing date. Now, you agents, stop putting in closing date on or before a certain date. Like if you're scheduled to close April 30th, don't put on or before April 30th. That does not demonstrate a meeting of the minds, and you can have issues if it says on or before April 30th, and then one party is ready to close on April 20th and the other party is not. Because the 20th is before the 30th, and you can have contract issues. So, okay, I've got a question. So let me talk about this just a little bit. Let's say the contract says you wrote in contract to close on or before April 30th. And so the seller has everything lined up for the 30th. They've got a moving company lined up. They've got somewhere to go. They've got their utilities scheduled. They've scheduled it with kids' vacations, days off, blah, blah, blah. Then the buyer says, hey, guess what? My loan's all done. The buyer's ready to close on the 20th. The loan is ready to go on the 20th. They call the closing attorney. They get on the closing attorney's calendar for the 20th. Buyer's agent calls the seller's agent and says, hey, guess what? We're all scheduled. We moved it. We're closing April 20th. And the seller says, I don't agree to that. I don't have anything ready to go. I have everything geared towards April 30th. And the buyer says, guess what? You already agreed, because the 20th is before the 30th. So stop putting that in your contracts. GAR used to have it in there. They took it out. And you'll see, I've already shown it, it has a firm closing date. So the question is new construction. New construction is a ground up new construction is a bit different. There is leeway in there because it is not built. And the new construction contracts address this issue based on availability, accessibility to materials and labor, and sometimes acts of weather can impact the closing. Additionally, if it is ground up new construction, they also have to rely on the county to get a certificate of occupancy. So that is addressed a little bit differently, and those delays or accounting for not a firm closing date, that is handled in the new construction contracts. But in the residential resale contracts, y'all stop putting that in. Put a firm closing date. If you're going to close early or later, change it via amendment. But regarding a unilateral right to extend, some agents mistakenly think that's Georgia law. That has nothing to do with law. That is simply a Georgia Association of Realtors contract provision. So let's take a look at that. In the GAR contract package, under paragraph B4A, it says right to extend closing date. And it says buyer or seller may unilaterally means it only needs one party's signature and the other party is held into contract against their will. Why do I say against their will? Well, if they agreed, then the parties would change the closing date via an amendment where they both agree. So if you have to use the unilateral extension, one party is not happy about it. So it's unilateral with one signature. It's extended for 8 days, but it is only for very, very specific reasons having to do with the loan not being done, as long as that delay is not caused by the buyer, or if the lender has not sent out the federally required, what we call TRID disclosures. There are certain financial disclosures a lender is required to send to the buyer 3 days prior to closing, or they and the closing attorney are federally prohibited from closing it. Or if the closing attorney doesn't have, can't fit you in their schedule, or there's a title issue, as long as the title issue is not something that, it's not a lien on the title or something that can be satisfied with money. It can only be used one time, not one time per side, but one time per contract. So very, very specific reasons. Now, the RE forms does not have the provision for one party to unilaterally extend the closing and hold the other party in contract against their will. However, I mentioned one of those reasons has to do with a federal regulation that we refer to as the TRID disclosures. TRID stands for Truth in Lending RESPA Integrated Disclosure. That's a whole nother long topic, but basically what you need to know for the purposes of this class is, as I mentioned, the closing attorney and a lender are federally prohibited from closing a transaction if the lender has not sent out these certain financial disclosures to the buyer 3 days prior to closing. Now, it's not cash to close, that can change. It's certain lender fees that can't change after a certain date. So if it's a federal prohibition to close, how is that handled in the RE forms? Well, let's look at that. So it's not a unilateral right to extend. It is a unilateral right to terminate by the seller. Why does the seller have unilateral rights to terminate? Because guess who chose that buyer? I mean, guess who chose that lender? The buyer chose that lender. If the lender didn't get the job done in time, that is still a contractual fault of the buyer because the buyer chose that lender. Not every lender is delayed. The buyer needs to make sure the lender does their duty, including sending out those complying with those federal regulations. So let me show you how that is spelled out. It's in the standard terms, paragraph 6.3.2. All right, so that's the contract. Here are the standard terms. 6.3.2 is under the financing section. And here's what it says. Underwriting guidelines prevail. Now, if any of those guidelines, and again, the guideline I'm specifically talking about right now are these TRID guidelines. That's a federal guideline. They have to send out those disclosures. If the guideline results in either an increase in cost or expense to the seller or affects the date of closing. So in my example, again, they can't close for they have to send it out at least 3 days prior to closing. So that would impact the date of closing. Then the seller, at the seller's sole discretion, may unilaterally terminate the contract. Now, the seller is limited. Once they know that can't close on the contractual closing date, first thing you would do is try to amend the contract to see if the seller would agree to a closing date. If not, the buyer sends notice to the seller, we can't close because my lender didn't send out the TRID disclosures. Closing attorney and lender can't close it on the closing date. The seller then has 3 days to say, nope, sorry, you should have been on them. I'm terminating the contract. I'm going to sell it to somebody else. You're out. You go find another house buyer. Or the seller can say, all right, I'm willing to hang in there. So if the seller does not terminate within those 3 days, then the seller's termination rights expire and the seller agrees to the new closing date. So again, it's a big difference. One is a unilateral, GAR has a unilateral right to extend the contract and keep the parties in contract. In the RE forms, the seller has a unilateral termination right. So if you're not familiar with this and you're a buyer's agent and the sellers and the lender doesn't get the job done in time with those trade disclosures, send notice to the seller. Seller says, adios, I'm going on and selling it to my backup buyer. Your buyer is not going to understand, and they're not going to be happy. Builder, yep, builder delays. You guys, you need to read those new construction contracts. There are some contracts that are intact for delays for up to 2 years. Y'all need to read those builder contracts verbatim before your buyers sign them. Well, they need to read them, but you need to be familiar with them. All right. Now, let's talk about the closing attorney firm and the verbiage about what happens if there's no loan. So we all know that if there's a loan, the closing attorney represents the lender. What if there is no loan? Let's take a look at that. So in the GAR form, it's in paragraph B5, where it talks about the closing attorney firm, and it says the buyer shall have the right to select the closing attorney. And it specifically states the closing attorney shall represent the mortgage lender. Now, if there is no, I don't have it underlined, but it's right here. If the buyer does not obtain mortgage financing, in other words, it's a cash deal, the closing attorney shall represent the buyer. But you agents, you make sure your buyers don't think they have legal representation should there be a dispute. That's not what the term represents the buyer means within this context. It means the attorney shall represent the buyer in preparing the closing documents, clearing title, working with the title company, offering title insurance, so forth and so on. Again, the buyer does not have legal representation should there be any dispute. Let's see how it's addressed in the RE forms. In the RE forms, it's in RE Form 100, which is the standard terms, paragraph 4. So let's look at that. Paragraph 4, closing. And it talks about up here at closing, I don't have it underlined. Is that where it is? Closing documents. Is that the right place? I might be. Oh, RE 100. Hang on. I'm sorry. It's in the actual contract. Sorry about that. All right, let me see. I'm getting myself confused. RE 100, paragraph 4. All right, so it's not in the standard terms. It's in the actual contract, paragraph 4. Here's where it talks about buyer does hereby authorize seller to communicate the buyer, closing attorney. Okay. I am confused. Somewhere in here, here it is, up here. I don't have it underlined. If the closing attorney is unavailable or unacceptable to the buyer's lender, then you fill in the blank, buyer or seller shall have the right to select a different closing attorney. So in the RE package, it just addresses which part, again, the closing attorney represents the lender, but if it's unacceptable to the buyer's lender, then you negotiate who has the right to select. That's all that is addressed. It doesn't use any of the verbiage about representation like the GAR does. And again, you need to be careful because buyers think they have legal representation if there's a dispute with the seller or with their broker or the other broker or something like that. Just so you know, parenthetically, in Georgia, a closing attorney must disclose in writing when they're closing a transaction for real property, which party they represent. So that's why GAR has that verbiage addressed in their contract package. The RE forms don't, but at closing, one of the documents your buyers and sellers sign that the closing attorney prepares is a disclosure as to which party they quote unquote represent. And again, it's not for over disputes. It's with respect to the paperwork. All right, now let's look at earnest money. When is the holder responsible to actually deposit the earnest money? And what about the form of the earnest money? So in the GAR contract package, the holder must deposit the earnest money within 5 banking days, and in the RE forms, 3 banking days. And again, this is spelled out. I'm glad I have these notes for me too. Paragraph B6, here's where it talks about here that the holder must deposit the money into the holder's escrow account within 5 banking days. And in the RE forms, it's RE 100, paragraph 3.1, which is the actual contract. And here's where it says it must be deposited within 3 banking days. So if I'm a seller, I'm going to want that deposit sooner, proof of deposit sooner rather than later. Now, what about the form of the earnest money? In the RE forms, it does not address. In the GAR contract package, it goes on to say that regardless of what the buyer and the seller negotiate, if it's a check, a wire, certified funds, ACH, the payment must be acceptable to the holder. So the buyer and seller can say, you know, we agree to ACH or electronic transfer. The holder can say, no, I don't care what y'all agree to. I don't accept that. So again, GAR says the method of payment must be acceptable to the holder. And if there's any fee, like any wire fees or bounce check charges, so forth and so forth, the holder can charge the buyer for any of those fees. So again, some of those issues are further addressed in the GAR. And now what happens if the buyer either never sends the earnest money to the holder, or they send, let's say, a check and it bounces from the bank or not bounces, but for whatever reason, the bank doesn't honor it. Then the holder, as I said, is required to send notice to the buyer and the seller that the buyer's in default, and the buyer has 3 banking days to cure that default. And the RE forms, the buyer has 3 calendar days. So again, regarding earnest money, the RE forms is a little more favorable to the seller. And both contracts say if the buyer does not cure that default, the seller has 7 days of that notice that hasn't been cured to terminate the contract. And then regarding the disbursement of earnest money. So once a holder has earnest money, then it's the same way to get it out, either with a closing agreement with the buyer and the seller, from a court, or from a 10-day letter. Again, as long as it's not cash and an attorney's holding it. Now, so those are the same in both contracts. The only difference, you agents binding on GAR, we've had a couple of issues where some sellers have been upset. If there's a contract and it fails to close, and the holder disperses the earnest money to the seller as liquidated damages from the buyer, the holder, look at this, some of y'all might not be aware of this, the holder may require the seller to sign a W-9 before sending the check to the seller if it's $600 or more. What does that mean? That means the holder is also going to report it to the IRS that seller made additional income, and they're going to send a 1099 to that seller that they're going to have to report as additional income and pay taxes on. This is addressed in the GAR contract and not addressed in the RE forms contract. So you guys binding on GAR, make sure your sellers know that if the buyer does in fact default or agree to give the seller the earnest money if it's over $600. All right. Now, where it talks about utilities, the GAR contract package states in the pre-printed that the seller is responsible for turning on the utilities. And in the RE forms, let me show you that. In the RE forms, it gets negotiated who turns on the utilities. So don't miss this. This is where it's talking about inspection of the property. And it says buyer or seller shall make all required utilities operational. So you agents going binding on the RE forms contract, you need to really look carefully at this, because some of these little check boxes are really teeny tiny small, and it's a bit difficult to see that. So make sure you check that. Now, point of practice. There are a lot of times when you buyers agents, when you are showing a property or you're writing an offer on behalf of a buyer, and you really need the seller to do something in order for the buyer to really fully take advantage of their due diligence period and fully assess the property, you need to address this in your contract. For example, if the utilities are not on, or another big example would be if you know the property is in a there's an HOA, but the seller has not completed the community association disclosure, so the buyer has no idea what the fees are. The fees to join this HOA might prohibit them from being able to buy in this property, and they would want to know that either before they make an offer or within their due diligence period, so they don't have to terminate and lose their earnest money. So listen to me for a second, you buyers agents. If you recognize that there is something the seller has to do, you need to protect your buyer's earnest money and their right to terminate with protection with a special stipulation. So a lot of you think you're going to put buyers, let's say the utilities aren't on. A lot of you are going to write a special stipulation that says buyer's due diligence to begin when buyer receives written notice that utilities are on and operational. Well, riddle me this, Batman. What happens if you never get that notice? If the seller never turns on the utilities, what happens if a buyer sends a termination notice? What's going to happen to their earnest money? Is it protected? If you have a special stipulation in a contract that says buyer's due diligence to begin upon written notice of that seller has turned on all utilities and they're on or operational, and you never get that notice and the buyer's going to terminate, is the buyer's earnest money protected? No. Why? Some of you are saying yes or thinking yes and just not typing it. Why? You're thinking, oh, well, they're terminating on due diligence. No, no, no. You just wrote a special stipulation that says their due diligence hasn't even started. They are locked into that contract. They do not have due diligence protection with that stipulation. So look at what I have highlighted. Point of practice. This is a special stipulation you need to use, you buyer's agents, if you know up front the seller has to do something. Buyer's due diligence period, or if you're binding on the RE forms, general right to terminate period, to begin upon binding agreement date. You always want it to start at the time you go under contract. Begin upon binding agreement date and extend for whatever, 3 days, 7 days, 10 days after buyer's receipt of written notification from seller that all utilities are on or operational. That so much protects your buyer, because then if the seller just walks off into the sunset and you never hear anything from them, they never turn on the utilities, then your buyer may terminate and you will get their earnest money back because they're in their due diligence or general right to terminate period. If, let's say, you had an initial 5-day due diligence period and you get notice from the seller on day 4 that they've turned on the utilities. Well, your buyer has 1 day to have it inspected, go over that and send an amendment and negotiate through an amendment with the seller. So that's why your buyer doesn't have to spend money on an inspection or be hurried to do this if the seller doesn't do it. So that's why it extends for X number of days after the seller performs. You get a copy of these sheets. Yes, they are available. I'll put one more time in the chat where these handouts are available, where you guys can go and download them for yourself. This sheet is available, as well as all of the contract packages with my red underlines. I just put it in the chat for you guys. And when we come back from break, I'll show you that. All right. My pleasure. All right, moving on. Buyers, inspection, and all of that information. A lot of this, in the GAR contract package, it's in paragraphs B8, A through C. In the RE forms, it is in paragraph 7. So I'm on the RE forms already. So this is where it talks about inspections, duty of the buyer to consult available resources. They need to check out if it's been a meth lab. They need to check out the sex offender list, so forth and so on. And in the GAR forms, it's in paragraph B8D. So this is, if you are not familiar with the 2023 GAR yet, they have totally reworked this paragraph and itemized everything out regarding inspection obligations. And all of that is spelled out regarding, same thing, check if it's a meth lab, check the sex offenders list, so forth and so on. So very, very similar regarding duty to inspect, and buyer and buyer's agents have a right to enter the property with notice to the seller through closing. They can't just barge in. Somebody else is living there and it's somebody else's home. Now, what happens if there is major damage from the inspection? In the both contracts, it basically says that the parties agree to hold the broker and the seller harmless, and basically the buyer is obligated to repair any damage caused by any inspections that they do, or any damage done by anybody they have hired to inspect the property. This is where it's addressed in GAR. In the RE forms, it is addressed in a couple of places in the actual contract under paragraph 7 and 12.98. All right, here's another huge difference in the contracts. The contingencies contained in the purchase and sale agreement in and of themselves. So in the GAR, I'm back here in GAR, the only contingency in the actual purchase and sale agreement is the due diligence period. Properties being sold subject to a due diligence period of so many days from binding agreement date. Any other contractual contingencies, I know I'm making you dizzy, hang on, must be addressed on a separate document referenced as an exhibit. So any type of backup contingency exhibit, any kind of financing contingency, any kind of lease or purchase, if they have to sell or lease their current home, that contingency, I'm sorry, that's where it is, lease or sale or lease purchase, a lease purchase agreement, any other contingencies, you have to attach a separate exhibit. And if a separate exhibit is not referenced or attached, then there are no other contingencies, only the due diligence if that has been filled in. That's in the GAR. Now, let's look at the RE forms. In the RE forms contract, again, this is the contract in and of itself. There are 3 built-in contingencies in the purchase and sale agreement in and of itself. One is the buyer's general right to terminate, which is the exact same as the due diligence. So that's the same as GAR. Then in the RE forms, a financing contingency and an appraisal contingency are contained in the purchase and sale. So if a buyer is going under contract with a seller and they want to make their contract contingent or subject to them getting financing, a lender agreeing to give them the money, and the property appraising for sale price, that's built into the purchase and sale, and you do not need any other documents or exhibits, period. Now, appraisal contingency, but you must mark these boxes. And so if it's being subject, if the buyer's earnest money and rights to terminate are going to be protected, that it must appraise for at least sale price, you have to mark this box. But what you'll notice in the contract, it says, this contingency shall expire at whatever time, 11:59 p.m. on the day that is so many days after the acceptance date. Well, what happens if it doesn't appraise for sale price? Well, then that is all spelled out in the document standard terms. That's why I beg of you to please, please, please use this. Where's the appraisal contingency? Use this form, attach it as an exhibit. So here's where it explains if it does not appraise for the sale price, then the buyer has the right to terminate and get their earnest money back, or you can negotiate for a lower sale price. So what happens if it doesn't? That's all spelled out in the in the standard terms. Now, financing contingency, let's look at that in the RE forms. In the RE forms, if you are making this contingent on a buyer talking a lender into lending the money, they have to do so or send notice of termination so many days from acceptance date, same as in the GAR. And then the terms of the mortgage, that's all spelled out here. First mortgage, you put in the percentage of sale price. Is it a fixed rate or adjustable rate? What the interest rate is, so forth and so on. So just like you're used to doing, you fill that out here. Now, one caveat I will tell you, if your buyer is getting a government insured loan, what do you think of when you think of government? Wait, that's a loaded question right now. Do not answer that. What I want you to think about is, if you think about government in relation to contracts, I want you to think about red tape or extra paperwork. So if your buyer is getting an FHA insured loan or a VA insured loan, when you are binding on the RE forms contract, you will need a separate exhibit. So government insured loan, separate exhibit. And it gives you a hint here. It reminds you, if buyer chooses FHA or VA financing, an FHA or VA financing exhibit shall be attached here too. And I don't know. Yeah. So here is a sample of so this is the only time for financing, if you're binding under the RE forms, that you need an exhibit. And there is a separate FHA loan exhibit that explains the amendatory clause and what the seller is responsible for paying, mortgage insurance, repairs mandated by the appraiser, so forth and so on. The only thing not contained in the FHA or VA exhibit in the RE forms is the time frame. Why not? Well, because the time frame is spelled out here in the contract under the financing contingency. So what do you do if you're binding on the RE forms and your buyer is paying cash? You've got an all cash buyer. What do? Well, guess what? You just do not check this box. If you do not check that box, then it is an all cash contract. Likewise, you guys, on these RE forms, you need to be careful. Even if you fill in this information, if your buyer is getting a loan, even if you fill in this information, you must check that box. Dana, why are you saying that? Well, I'll tell you why I'm saying that. Here, let's look at the appraisal contingency. This contingency shall only be granted by the seller if the appropriate box related thereto is checked within the body of the contract. So it doesn't matter if you fill in the blanks. You agents going binding on the RE forms, you must check that box to make the contract contingent upon that. In the GAR forms, again, if your buyer's making the contract subject to or contingent upon getting a loan or getting an appraisal, those are addressed as a separate exhibit, and we'll go over those differences a little bit more in just a second. All right, let's talk about repairs. What time is it? All right, all right, let's talk about this and a couple more things, and then we will take a break. Under repairs, both contracts address repairs, but the only verbiage that they have is, Lawrence, I'll answer your question in just a minute. The only verbiage, pre-printed verbiage, where it addresses repairs, in the GAR contract and the RE forms contract, that says repairs must be done in a good and workmanlike manner. GAR says prior to closing. RE says 3 days prior to closing. Point of practice. There are a lot of issues that you guys do not think about far enough in advance. And what you think is not necessarily true. And what I mean specifically is if a buyer and seller negotiate for repairs and the seller does not complete those repairs or complete all of their repairs, your buyers do not necessarily have termination rights to protect their earnest money. So you negotiate that, you do a final walkthrough and the seller hasn't done them or has not done all of them. And you're like, well, my buyer's going to terminate. Well, if you terminate your buyer could very likely just have lost their earnest money by being in default of the contract. So a couple of points here. Number one, a breach in contract, the remedy for various breaches in contract is not necessarily termination rights with the earnest money as liquidated damages. Different breaches call for different remedies. You buyer's agents, at the time you are negotiating with a seller to do repairs, if you want to address that they may have termination rights, you need to address that at the time. You can't bring up their right to terminate and get their earnest money back a day before closing. So part of the contract package that I have available for you to download are a document that we have called special stipulations to consider. A lot of these stipulations have been authored by various closing attorneys, by GAR, by the RE forms. I have them outlined for you in a table where you can see them. There are a lot where we talk about repair issues. Further down, let me see, repair issues. There are a lot of repair issues where you have to build in. I'm not going to go over those specifically right now, but this is available to you as in any CE class you take. Any special stipulations before you use them, you definitely want to make sure that your broker approves them. But my point is, if you are actually negotiating for repairs, when you make that negotiation for repairs, you need to build in a special stipulation, a buyer's recourse should the seller not do them. And when at all possible, rather than actually negotiating for a seller to make repairs and pay for those repairs, sometimes it's not possible, but when it is possible, it is by far a better situation to handle those financially. And I would ask you to consider this special stipulation. At closing, from seller's proceeds, seller to pay X amount of dollars to ABC vendor. If you use this stipulation, then a buyer doesn't have to worry about a seller finding the cheapest person to do it. A buyer will get full warranties. A buyer can schedule it on their own. And this stipulation does not impact a buyer's loan because it's not a financial contribution from a seller to a buyer. So again, rather than actually having a seller make repairs, when at all possible, I think it is by far better to use this special stipulation. All right, let's go ahead and take a break, and then we'll knock out the rest of the GAR and then go over some of the other differences. So I have 11:10. Let's come back in 15 minutes. So let's come back at 11:25. When you come back, type in again your name, your license number, and your email. And let's take a quick break and we will knock out the rest and be done by 12:30. So come back at 11:25 and I will see everybody shortly. All right, welcome back from the break. We have a lot to cover, so I'm going to talk a little bit more quickly. And I think I'm really just going to point out more of some of the differences rather than the similarities. Thank you, Susan. I've just addressed where agents can find my videos on the YouTube channel, Real Estate Made Crystal Clear. Thank you so much. I do approach that as a resource for agents in the state of Georgia with a lot of contract issues and license law issues. So I'm so glad you find them helpful. I really, really love teaching, whether it be CE classes or via the videos. So, all right, we are going to continue on. Thank you guys so much. We are going to knock out the rest, and we are still continuing on with the purchase and sale agreement. We're going to cover that, some of the loan exhibits, and then some other differences in some of the other main exhibits. So where the contracts also talk about broker and agents' limits of authority. And in essence, both of them do refer to if a public person is working with your broker as a client, it references a brokerage agreement that public person has signed. And both of them also say that the buyer and seller have not relied on any given or implied advice from the broker and agent. In essence, you are acting within your capacity as real estate agent. Your broker is acting within the capacity as real estate broker. We are not attorneys. We are not inspectors. We are not appraisers. We are not investment guides. We are not termite people. We are not surveyors, so forth and so on. New in 2023, for those of you working with the GAR, your clients like the GAR contract packages, there is a reference under the agency section to an agent having both sides of a transaction, but not dual agency. So that's new in 2023. And then also it goes on, both contracts go on to say, just further explain the broker and the agent disclaimer that you are acting within the capacity of a real estate agent. And again, it references the brokerage agreements. GAR goes on to say that any special stipulations that are written are for the parties' benefits, and they approve of that. And part of that is GAR is saying, we didn't write these, your agent wrote those. Additionally, GAR goes on to specifically address that any questions that are answered, that are asked by a buyer or a seller, specifically of a buyer, the answer given by the agent or broker is provided from the seller. That is pre-printed. Let me just show you guys where that is. That is pre-printed in 201BC. That's in the GAR contract package. They have a lot of information about their contract, but it does say, let me see where that is again, B10C. Here we go. I'm sorry, I'm in the wrong place. Here we go. It's under the disclaimer, and it does specifically say that if a broker answers a question of a buyer, or otherwise describes some aspect of the property, broker is doing so based upon information provided by the seller rather than independent knowledge of the broker. Now, I will tell you there is a form. Let me see if I have it here. Yeah. There is a form that GAR has called Broker's Information Disclosure. This is a great form to use as an agent where you can put it in writing. You reference the property, you put the agent's name, has been asked the following questions by buyer, whomever. The question, the answer, and the source. And then it goes on that basically says this information is not guaranteed or complete. Party receiving should independently verify. But that way you keep track in writing of the questions and the answers and the source of those. That's just a useful form that GAR has provided. Then both of these, when it talks about notice, again, I'm not going to go in depth in this. We cover notice issues in depth in we have a whole 3-hour CE class on the GAR contract package and a whole 3-hour CE class on the RE forms contract package. Again, the purpose of this class is to point out the similarities and the differences between the two packages. But basically, if a party is sending notice to the other party, if you're sending it electronically, there's no way to prove when the receiving party opened it, read it, so forth and so on. So GAR has wrestled with this issue over the years regarding when notice is deemed received. And as of the past couple of years, and the RE forms has this. Basically, it says a notice to a party shall be deemed to have been delivered and received when it's electronically. So email, that's the majority of way, the primarily used method by which agents on behalf of their buyers and sellers send notices by email. It is believed to have been delivered and received on the date and time when the notice was electronically sent to an email or fax number of the party given here. Even when it's not open. GAR goes on to say, even when that email was not opened by the recipient. So in the RE forms, it has the same verbiage. So in essence, what that means is, let's say your buyer's due diligence ends tonight at 11:59 and they're going to terminate. Well, the buyer signs a termination notice and you send it to the listing agent or the seller's agent at 11:58 p.m. Well, that agent doesn't read it until tomorrow, or open the email until tomorrow, or send it to the seller until tomorrow. Well, tomorrow is after due diligence. Nevertheless, the buyer will still have protected their earnest money by having sent notice. The contract says it is deemed to have been received when the sender can prove they sent it. So the buyer did send their termination prior to the end of that due diligence period. That's just an example of why that is important. But you have to send it to an email address or fax number on the contract. So if that changes, you need to give notice to the other party. And then regarding default, this is the same in both contract packages now. GAR changed theirs the RE forms changed theirs in 2019. Basically, if a buyer defaults, fails to close, and they're outside of all their contingencies, the seller's sole remedy is to keep the earnest money as full liquidated damages. In the RE forms contract package, it is the same. If a buyer defaults, terminates the contract, or fails to close, and they're outside of all the timeframes for their contractual contingencies, the seller's remedy is to keep the earnest money as liquidated damages. Now, the RE package used to say any remedy under the law, meaning the seller could sue the buyer for damages. And I had a moving truck lined up, so you owe me money for that. I lost out on another contract. You owe me money for that. I have to pay a reconnection fee for my utilities. You owe me money for that. Those are damages. And that's what the RE forms used to say, but they have now changed it to just the earnest money. Now, don't get me wrong. Your contracts say that the sole remedy is earnest money, and not that they cannot sue for damages. You guys, the public can sue the public for anything. They can sue for anything. But what that defendant's lawyer should argue is, when you went and signed this purchase and sale agreement, you agreed that should there be a default, you would be happy with just the earnest money. So, like I said, when you say you can't sue me for that, anybody can sue for anything, but the grounds for that lawsuit would be based on, again, that's what an attorney would argue. And then if the seller defaults, if a seller doesn't close or terminates a contract outside of any agreed upon contractual contingencies, the buyer either terminates the contract and gets their earnest money back and goes and finds something else, or they keep the earnest money in the deal and they go to court and sue the seller for what's called specific performance, meaning the judge would make that seller go ahead and go through with that contract and sell it to that buyer. And again, in both contracts, if there's a party that defaults, both brokers may pursue the defaulting party for the commission they would have earned had it closed. All right. Moving on to the condition of the property. This is a little bit of a big deal. little bit of a big deal. That's sort of, what's the word I'm looking for? When they're opposites. Anyway, on the GAR contract, it says in paragraph C3, where it talks about risk of damage to the property, it says that the seller warrants at the time of the property and the property itself at time of closing, the property itself and all items remaining with the property. Oxymoron. Thank you, Judith. That's the word I was looking for. Shall be in substantially the same condition they were at time of offer. The RE form contract package in the standard terms, paragraph 7.3, it says, that's the contract standard forms. Here we go. 7.3, when it talks about the condition of the property, it says the property shall be in, where is it? 7.3. The same condition as closing as it was on the date of acceptance or binding, normal wear and tear accepted. They both say broom clean and all debris removed. What is the difference between substantially same condition and normal wear and tear? Well, there was a court case here in Georgia several years ago, and that's why GAR changed it. GAR used to say normal wear and tear accepted. And the essence of that court case was buyer was buying a 20-year-old home, and the HVAC was about 20 years old. And when they wrote the offer and at binding, the HVAC was working. When they did their final walkthrough, it was not working. Buyer didn't close, went to court, said the seller had the duty for that the HVAC should have been working. Well, the judge ruled that the contract said normal, again, at that time, the GAR contract also said the property be in same condition, normal wear and tear accepted. They said it's a 20-year-old HVAC. That's pretty normal for it to poop out at about that time frame. And the judge ruled in favor of the seller. Since then, GAR changed that verbiage to write that the property shall be in substantially the same condition. A non-working HVAC is not substantially the same condition as a working HVAC. So that can, again, nothing's an issue till it's an issue, but that is, that's why that verbiage is a bit different. And then both of them go on to say if the property is substantially damaged, if it is damaged by a weather incident, or by extreme vandalism, then the parties can either stay in contract and the seller fixes it back up and then they close, or either party may terminate, or a buyer can say, I'll take the property. I was going to tear it down anyway. I'll take the property and take whatever insurance proceeds. And then any changes or termination of the contract have to be in writing. And then for any of you guys working with investors who are assigning contracts, it is not referenced. An assignment of a contract is not referenced at all in the RE forms package. In the GAR package, it specifically states in paragraph C4E in the purchase and sale that the contract may not be assigned without the seller's written permission. So point of practice to you guys working with investors who are going to assign a contract. Please note that there is a special stipulation 611 where a seller does agree to assign the contract. So make sure you buyer's agents working with investors, you include that in your offer. And then if it does get assigned, there are two forms. One of them is new in 2023. That this is an assignment agreement between the assignor. This would be between the investor and the end buyer living in the house. And this is a new form in 2023, an amendment between the assignor and the seller. So I'm not going to cover that in depth. Just wanted to bring that to your attention. I've already addressed extension of deadlines. The GAR contract says nothing gets extended automatically if it falls on a weekend or holiday except for closing. And in the RE forms, the only extensions addressed are specific to new construction. Why am I bringing that up in this class? Because the GAR references that in their new construction contract. Well, again, remember at the very beginning, I said the RE forms have a lot of multi-use forms, the RE package. Well, even the standard terms are multi-use. So you will see, for example, the standard terms are also to be used with new construction. So if you look at 7.2.5, this is the standard terms. They are used for residential resale contracts as well as new construction. And so here's where it talks about change orders and extensions. And this is in reference to new construction. So that again is an example of a multi-use form. Brand new in 2023 is this FIRPTA affidavit, which has to do with the Foreign Investment and Real Property Tax Act, not referenced in the RE forms. I'm sure your closing attorneys would have some disclosures and information. Basically, it has to do with a foreign investor, the closing attorney having to collect taxes up front at closing for that. And under the GAR forms, under the GAR form use, they reference that here, there's a whole section under the GAR forms that you must be licensed to use. In other words, you cannot just give your GAR forms to the public. You cannot, the GAR, excuse me, the GAR forms, regardless of what the parties think, the courts can interpret them differently, and that nobody is required to use the GAR forms. So that is all spelled out. Nobody's required to use them. The courts may rule against them, and you must be an authorized user. Use of the RE forms is not referenced. No authority to bind, that's in both, where basically it says you as the agent cannot sign a contract and your public people be bound to it. They have to put in writing and sign what they agree to and not agree to. In other words, an agent is not a power of attorney for a client. And regarding binding agreement date, the GAR form addresses any issues or confusion or discrepancies on the binding agreement date. It spells out, actually GAR addressed this in 2022 pretty extensively, where it talks about, here it is here. There's a lot of information on binding agreement date and what to do if there is a discrepancy over that. The RE forms does not address that, it just defines it. That is important just in general as a point of practice to get on the same page immediately regarding that, because that is day 0 for the counting of all of your contingency timeframes. And then regarding, this is spelled out in the contracts itself. You guys all know this from pre-license school, that the hierarchy of control. So if I'm going to go backwards, so a special stipulation, anything written in a special stipulation takes precedence or supersedes or controls over information written in an exhibit, which supersedes or takes precedence or controls over information that is handwritten, which supersedes, takes precedence, or controls over anything pre-printed. That is the same in both contracts. And also in both contracts, an amendatory clause, which is the appraisal contingency, so to speak, for a buyer getting an FHA or VA insured loan, that information takes precedence over any special stipulation or anything else in the contract. In other words, if a buyer is getting an FHA or VA insured loan, property does not appraise for sale price, the buyer may terminate through day of closing and they will get their earnest money back. That's true in any contract and regardless of any special stipulation or exhibit. Now, the buyer can't just not show up. They have to send termination notice based on that, but their earnest money is protected on a government insured loan. Then GAR references a statute of limitations for a party to raise a claim against another party as 2 years, not referenced in the RE forms. And then this is another big difference. Got a lot. What survives the contract? Well, what does it mean to survive the contract? That means that that is something that the parties are still legally obligated to uphold even after the closing date. So in GAR, it specifically itemizes certain things: commission, title, written warranties of the seller of the property in the neighborhood, buyer indemnifying the parties if they damage the property from an inspection, if the property is condemned, attorney's fees, property taxes. And then GAR goes on to say, any obligation the parties agree shall survive closing. RE forms, they say basically everything in the contract survives closing. So even after you close, the buyer and the seller are still legally bound to what they agreed to do if they didn't do it prior to closing. That's a bit different. And for example, a seller paying for a home warranty for a buyer or repair issues, those are not specifically spelled out. So if you negotiate and a seller was supposed to pay for a home warranty for a buyer and they don't do it, and you close and the buyer says, hey, you forgot to buy that home warranty for me, the seller is no longer legally obligated to pay for that home warranty for the buyer because it's after closing, and that does not survive closing unless, because GAR says anything the parties agree. So if you negotiate in a contract and you say, seller to provide a home warranty for a buyer, not to exceed X amount of dollars. If then you use this magic phrase, this provision shall survive closing, if you forget to call it in at closing and you close, because they agreed that survives closing, now the seller is still contractually obligated to pay for that for the buyer. Then this is the same, all of this is the same. The definition of days is the same. If it just says day, it's a calendar day. If it says business or banking day, it's Monday through Friday except federal holiday. That's the same. A disclaimer and warning about cyber fraud is the same. Broker and agent liability is the same. It talks about it being limited to commission. GAR goes on to say if there was no commission earned, then it's only $100. And then there is verbiage about technology and privacy. Basically, everybody nowadays walks around with a video recorder and a tape recorder, and there's just a disclosure that, okay, sellers, you've got people walking through your home. Just know, regardless of the best efforts of agents and brokers, your home may be videotaped or pictures taken. Then there are a lot of consumer brochures and disclosures available to you in both sets of packages. Point of practice, you guys, you need to be able to demonstrate. You need to get these brochures and disclosures to your clients and customers. All right, I've got 30 minutes to knock out the rest, so hang with me. Some of this stuff we have already addressed regarding the loan contingencies. If the parties are binding on the GAR contract, if it is a cash transaction or a buyer is getting a loan, but they're willing to risk their earnest money if they don't get their loan, you have to use a separate exhibit. And again, these exhibits, we've already addressed this a little bit, are referenced on the purchase and sale. And then you would need the exhibit. Let's see, we don't need that. We don't need that. We've already talked about that. We've already talked about that. Oh, when I was talking about the getting on the same page of the binding agreement date, this is GAR has this form, binding agreement date confirmation. If on the purchase and sale agreement, you fill in the binding agreement date here and there's no issue, that's fine. If there's an issue, you need to get on the same page, and I would suggest you use this GAR binding agreement date confirmation amendment. Okay, here is for an all cash deal. In 2023, GAR took out the word cash exhibit, and just labeled it no financing contingency. So there is a provision if the buyer is getting all cash, or if the buyer is actually getting a loan, but they're willing to risk their earnest money. In other words, if they don't get their loan, they're not making their transaction contingent upon them getting the loan. If they don't get it, they're willing to risk their earnest money. The only difference between this exhibit versus using a conventional loan exhibit and putting 0 days would be, this is new in 2023. If you use this new exhibit or revamped exhibit, there is no provision for an 8-day unilateral extension if the loan isn't done. The only way you could use the 8-day is if the closing attorney isn't ready because of a title issue or a scheduling issue, not because of a mortgage lender. So that's the only difference. In the RE forms, we've already talked about this. If it's a cash deal, you simply do not check that box. And then again, the financing contingencies. GAR has separate contingencies, and the time frame for the contingency, as well as all of the terms of the financing and what happens if they don't get their loan, how they terminate, when they terminate, loan denial letter, all of that information is all spelled out in the GAR contract package on the contingency exhibit itself. In the RE forms, the time frame for the financing and appraisal contingency is spelled out in the contract. The terms, what happens if they don't get their loan, termination rights, notices, loan denial letter, in the RE forms, that's all spelled out here in the standard terms. What happens if they terminate? They have to prove it with a loan denial letter. This is what the loan denial letter may or may not be based on, so forth and so on. But the time frame is in the contract. The only big difference between these two is if now both of them, FHA and VA, again, buyer may terminate immediately and get their earnest money back. In the GAR, if a buyer is terminating based on if they're terminating based on financing, in both contracts, you still have to prove it with a loan denial letter. But in the GAR contracts, the buyer may send the loan denial letter to the seller 7 days after they terminate. In the RE forms contract package, if a buyer terminates under the financing exhibit, they still have to prove it with a loan denial letter, but they have to send that loan denial letter simultaneously with their termination. And that's that information up there. And then again, what the loan denial letter may or may not be based on. Both contracts say that if a buyer gets turned down for their loan, and their loan denial letter says that's the reason they're not getting their loan is because they don't have the cash to close. In other words, they don't have their down payment money. That does not meet the terms of the financing contingency. In other words, they will also lose their earnest money. So point of practice, you agents, if you are working with a buyer getting down payment assistance funds, that is not protected. Their earnest money is not protected in the financing contingency if they don't get that. You've got to use a special stipulation making the contract contingent upon the buyer getting those funds by a certain date, and then put termination rights in there. You don't have to remember all this. Just go here to these special stipulations I'm sharing with you guys. And we have this verbiage here, down payment assistance funds, making the contract. That's in both GAR and RE. You need to protect your buyer's earnest money if they're getting down payment assistance in case they don't get it. Again, both FHA and VA, if they get denied, that still falls under financing contingency. If it doesn't appraise, that's where their earnest money is protected. And again, everything with FHA and VA is the same regarding repair costs get negotiated, who may terminate if the repairs are more than they negotiate, so forth and so on. So all of this, I believe we've already addressed, very, very similar. Again, just a point of practice, both contracts, if the buyer is getting an FHA or a VA insured loan, they still may terminate if the property does not appraise, and they will get their earnest money back, even if you use an appraisal gap stipulation. So you listing agents, no trickeration by these buyers. If there is a concern or an issue with appraisal and the offer includes that appraisal gap stipulation saying the buyer agrees to bring X amount of dollars over sale price if it appraises low, that is not enforceable if the buyer's getting an FHA or a VA loan. Completely unenforceable. Don't be tricked. That's all of that. We've talked about that. I have it twice for you. Costs associated with an FHA or VA loan, that's similar in both. In the RE forms, it does say where a buyer's getting a VA insured loan, it does say the seller to pay costs associated with the VA loan that the buyer's not allowed to pay. In the GAR VA loan exhibit in 2023, they've changed it to negotiate either the buyer or the seller may pay for the initial termite clearance letter, but after that, a seller is required to pay for any updated letters should there be any damage. All right. Counter offer is basically the same. And if a buyer and seller go back and forth on a counter offer, then you only have one binding counter offer. So any terms that get negotiated in intermediary counter offers don't count. You have to carry those agreed upon terms through to each successive counter offer. All right, let's talk a little bit more about some of the differences. Seller's property disclosure form. Let me get rid of that. That's a counter offer. All right. In the GAR, seller's property disclosure form, it basically says this is to the best of a seller's knowledge information about the house. Yes or no answers. If there is a yes, they have to write out an additional explanation here. And there is a space at the end where it talks about, sorry if I'm making you dizzy, it talks about items that a seller, these look like personal property items that a seller is taking with them or leaving in the house. Buyers are instructed that this is information to the best of the knowledge of a seller, but Georgia is caveat emptor, and the buyer should still do a thorough inspection and not necessarily rely on this information. In the RE forms package, there is also a document called a seller's property condition disclosure statement. Again, information known by the seller, not a warranty of any kind by the seller. And same thing, buyer, you are instructed to still check out the property yourself. Now, in the buyers, in the RE forms one, there is an unknown. GAR used to have that, they got rid of that. About easement, so forth and so on. Yes, no, or unknown. So GAR has yes or no, RE has unknown. The other huge difference is when it looks like these personal property items, in the RE form seller's property disclosure statement, it says, have there been any known material defects? Yes, no, unknown, or not applicable. There is nothing about these items staying with the property or a seller removing them from a property. So you agents, when you go binding on the RE forms, if there are certain fixtures that a seller is going to remove or keep with the property, you need to address those. I suggest you address those on a bill of sale, which is RE Form 1-2. Additionally, GAR, as of, I believe it was last year, either last year or 2 years ago, they created a new form, which is this seller's disclosure of latent defects and fixtures checklist. This is only a 2-page form. The intent of this form is for a seller that has never lived in the property to fill this out. That basically, if it's an investor, or if it was a foreclosure, or if a seller is selling the property and they inherited the property, or they're the executor or administrator of an estate. It does give them the chance to comply with Georgia law to disclose any latent defects, and it does have this fixtures checklist. The issue was a lot of owner occupants are like, I'd rather fill this out than that long form. So last year they changed, I guess it came out 2 years ago. And then last year they changed it to say seller occupies or is most recent occupant. Seller was not the most recent occupant. In other words, there were tenants in there, or somebody else lived in there, or seller has never occupied. The RE forms does not have this short form. All right, community association disclosure, basically the same. And in both of these forms, let me get rid of that. This is the GAR one, and it is pretty lengthy. And this is the RE form. In essence, in both of these forms, the seller will be charged at closing with any fees that they did not disclose or that have gone up. This is not intended, this is in both RE and GAR. This is not intended to be a punishment for a seller. This is a reflection of the fact that a lot of property management companies, HOAs, will not disclose certain fees to a buyer, to a buyer's agent, even to a seller's agent. They will only disclose these fees to the seller on title. So this is saying, okay, seller, we need your help. You need to determine what these fees are so that a buyer may make an informed, consented decision to buy this house with this HOA. They need to know what the costs are going to be. And if you don't get those for us, you're going to have to pay those at closing because you're the only one that can get them. But again, that charge to the seller is very similar in both GAR and RE. In the sale or lease contingency exhibit, very similar, but the GAR one, again, 2 or 3 years ago, they really revamped this. And they put a lot more control into the seller's hands. A buyer saying, okay, I want to buy your house, but I have a current home I have to sell. Will you sell your house to me and give me the opportunity to sell my house in order to buy your house? And a seller says, sure, I'll do that. However, I'm going to have a little bit of control over what happens with your current home. So GAR, again, revamped this a couple years ago. And you'll see all of this in here. At the time of offer, buyer warrants that the property is currently listed, and you identify the broker. Is currently under contract, and you identify the buyer of that contract. It is contingent, the purchase and sale for the new home is contingent on the buyer closing or leasing their existing home by this date. If it doesn't, this contract automatically terminates. Now, if you buyer's agents, if you get a seller to agree to go under contract with your buyer and they have a house to sell and you're currently under contract, if the contract on their existing home terminates, you need to let this seller know immediately. And you listing agents, if that happens, you sellers, they have the right to ask the buyer to remove all contingencies, or they can terminate this contract and go on to another buyer. Additionally, there is a kick-out clause where a seller can say, yep, I'll take your contract. I know you have to sell your house first, but in the meantime, I get to continue to market my house as active. And if I get another house that I want to, another offer that I want to accept, I'm under contract with you. So I'm going to go back to you and say, I'll stay with you, but you have to remove all contingencies, or you have to remove certain contingencies. So all of that is spelled out in this form. Again, GAR gives these sellers a lot more control over what happens with the buyer's property. In the RE forms, they also have a sale or lease contingency exhibit, and it does have a kick-out clause. So in other words, the buyer says, okay, seller, you still have the right to offer your property for sale to someone else, but before you're free to accept another contract, I either have the opportunity to remove contingencies and stay in contract with you, or terminate and get my earnest money back. So the seller has the right to kick out this buyer. So that's similar. It's just the GAR has a lot more influence and control over the information regarding the buyer's home. All right. Now, regarding, let's say a buyer and seller go under contract, and the contract has a due diligence period or the buyer's right to terminate. Well, again, a buyer during this time frame, they're trying to decide if they're going to go through with the contract or if they're going to terminate the contract. So during this time frame, they're going to check it out and see what they're buying. And during this time frame, a seller has incentive to play nicely with the buyer to keep this buyer in contract. They don't want the buyer to terminate. They took their contract. So there is an amendment. The buyer does all of this, the inspection, so forth and so on. And then the buyer can say, hey, seller, I'm still trying to decide if I'm going to stay in contract or terminate with you. So I found some things, and I'm curious if you will address these or not. So this is when a buyer says, seller, I want you to fix A, B, C, D, blah, 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 blah. Couple of things about this amendment in the GAR contract package. First, down here, if the buyer does agree to everything, if the seller does agree to everything the buyer is asking, you have the option of saying, okay, if I agree, this is going to end your due diligence period. So let's say in the contract you had a 10-day due diligence period. Buyer has the property inspected, sends over this amendment asking for everything on day 4 from binding agreement date. Seller agrees. If this is marked shall, that's it. The due diligence period ends early. So that's in this contract. Additionally, this is the only amendment that has a time limit. And what this says here in this paragraph is this amendment is intended to set forth this agreement relative to the concerns raised by the buyer during due diligence. If this amendment does not become effective during the due diligence period, in other words, buyer and seller don't both sign before the end of the buyer's due diligence period, it becomes null and void and of no legal force and effect. So a couple of things here. If a buyer has the property inspected, sends this seller an amendment to address concerns. If the seller says, so the buyer says, I want you to do A, B, C, and D. The seller sends a counter amendment saying, I'll do A and B, but not C and D. If that counter amendment is not signed by the end of due diligence, let's say we've gone past due diligence, and then the buyer signs it, The seller's not obligated to do that, even though you've got a fully executed amendment. If it was fully executed after the end of due diligence, it's not part of the contract. It is not enforceable. Additionally, one thing to remember, an outstanding amendment to address concerns being negotiated does not extend a buyer's due diligence. They either need to terminate or they're buying the property as is. Now, in the RE forms amendment during the buyer's right to terminate period, there's no verbiage about the time limit on it. There is this verbiage down here that if this amendment is not signed, so a buyer says, I want you to put on a new roof. If the seller does not sign it before the end of due diligence period, then the buyer has the option of saying this shall act as a unilateral notice of termination. You would do that to protect your earnest money. So here's what a note I have for you guys to remember. If the seller does not agree by signing and sending it back to the buyer prior to the end of the due diligence period, then that will terminate the contract. You only want to mark shall if it's what I call make it or break it issues. If it needs a new roof, if it needs a new foundation, something like that. If it is just like reverse the polarity in the bathroom or repaint or something like that, but your buyer still wants the property, don't mark that, or you've just terminated the buyer and the seller can go accept another contract. All right. Another big difference is the temporary occupancy agreement for the seller after closing. This is a pretty big difference between the GAR package and the RE package. This is the GAR one. This is the RE one. Nope. Both of them have the date of occupancy. You're closing, but the buyer agrees to let the seller stay in the home for a certain number of days after closing. Now, in the RE package, there is this paragraph about compensation, and they call it a usage fee. The seller shall pay the buyer at closing a usage fee of X amount of dollars or X amount per month, beginning on such and such date. Basically, the buyer says, this is now my house. So for me granting you the privilege of not having to move prior to closing, I'm going to do that, but you have to pay me X amount of dollars. And then it goes on to say the seller is not a tenant. And if the seller does not, it's in here somewhere, the seller has to maintain the property, so forth and so on. But the only fee addressed has to do with a privilege fee for staying in the property. In the GAR form, in the temporary occupancy agreement for the seller after closing, they still have a date when they have to get out. They still have to maintain the utilities, so forth and so on. The only dollar amount in here is not for the privilege, the buyer granting the seller the privilege of staying in their property. This is just a dollar amount. If you don't leave when you say you're going to leave, you owe me X amount of dollars per day that you stay in there after you said you were going to leave. Well, first of all, if the seller doesn't leave when they say they're going to leave, the buyer's probably going to have to judicially enforce that to get that money out there. But there is no dollar amount in here for the seller that the seller pays to the buyer for staying in their property. So that's a pretty big difference. All the other stuff is the same regarding they're not an actual tenant because you don't want the Georgia landlord tenant laws to kick in, so forth and so on. GAR has just added this last year, which I really, really love. That's basically saying, okay, buyer, okay, seller. If the seller is going to stay in the buyer's home after closing, because the buyer now owns it, Both of y'all need to check with your insurance companies and make sure you have appropriate insurance. Seller, you no longer have insurance on the structure, so you need to get, in essence, what sort of renter's insurance to protect your personal belongings. And buyers, you now own the property. You need to make sure that you are insured with somebody else staying in your property for a temporary period of time. So, but that usage fee is a pretty big difference between those two packages. Closing attorney holding earnest money, we already addressed that. And termination and release, another fairly big difference between the two properties. The termination and release of a contract are two separate contractual issues. One is terminating. Anybody can terminate a contract. The issue is, did the party that terminate by default or terminate by an agreed upon unexpired contingency? You only need one party signature to terminate, buyer or seller. The release and disbursement of the earnest money is a completely separate issue. And that is either agreed upon by the buyer and the seller, or if not, then the holder of the earnest money goes back and interprets if this was done by default or by contingency. Two separate issues. GAR addresses these on one document. In the RE forms, handle these two separate issues on two separate documents. The first one is, this is the termination of a contract. This is what actually terminates the contract. You would also need the separate form to have the parties agree on the disbursement of the earnest money. And the separate form is this one, agreement to disperse the trust funds. So again, in any contract, it is two separate issues. Termination is one issue. Release of the earnest money is a separate issue. RE handles it on two forms. GAR handles it on one form. So pop quiz. GAR contract is designed to protect whom? RE is designed to protect whom? Type it in the chat. GAR and who they are, and RE, who are they designed to protect? I want to see your opinion. Couple more things and then we're done. Type it in the chat. Who do you think the GAR contract is designed to protect? Who do you think? Buyer, seller, buyer, seller, buyer, seller, buyer. Both parties for each. Buyer, seller, both. All right, this was a little bit of a trick question. Both the GAR and the RE forms. You can see, as I sort of point out, both of them sort of have, some provisions are a little bit more favorable to a buyer. Some provisions are a little bit more favorable to a seller, but both contract packages are designed to protect you, the agent, and me, your broker. They're designed to protect agents and brokers. Okay, Dana, why are you saying that? There is a ton of pre-printed verbiage. The majority of all of this pre-printed verbiage in the GAR package and in the RE package, in the standard terms and the contract, that has a lot of disclosures to protect us. And it has a lot of disclosures we as agents are required to include via license law. For example, this disclosure right here, the broker is representing the buyer as a client or the seller as a client. That's in GAR and RE. Guess what, you guys? You know why that's in there? Not only to inform the parties, let me go up here in the GAR, here's where it is in the GAR, the brokerage relationship. That is a requirement of license law, that in a contract, if you are working with the public as a client, you must make that disclosure. A lot of that is not included in, for example, a new construction contract or an attorney written contract. It's still enforceable between the buyer and the seller, but you are out of compliance with license law, which could have impact on your license. So it was a little bit of a trick question that both the GAR and the RE forms contract packages are designed to really protect you and your brokers. Now, in these handouts that you have access to at the end, again, I do have all those special stipulations, and I have a lot of general contract reminders. A lot of this is to stay in compliance with license law. So I do encourage you guys to read all that stuff, and look at everything. Again, please refer to your own broker with all of your contract questions, or an attorney. GAR has a legal helpline. That is my YouTube channel. That is all the information is available in the handouts. And I will stay on to answer whatever questions you have. If you are leaving, one more time, please type in your name, your license number, and your email address. And I thank you guys so much. We made it. I hope the 3 hours went by very quickly, and I hope you got more out of the class than you bargained for. And I so appreciate your time and attention. And I thank you guys, and I will stay on for questions. Because there is a lot of everybody signing out on the chat, if you do have a question, feel free to unmute yourself and ask. But just mute yourself when you're not asking so everybody can hear. And I thank you guys so much. Go be a blessing to everybody with your license. Buyers and sellers are out there, and they do need your assistance with their real estate needs. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.